All right, good evening, folks. Welcome to Monday Night Law, May 20th, 2024. How's everybody doing out there? Had a fine time camping, dirt biking. Didn't catch any fish, but gave it a drop in the water. Oh, that's gonna be notification. Boy, do I have some interesting, good stuff to share tonight regarding the Second Amendment. As some of you may be aware of, I've talked about this before. The Bruen case, that's the New York State Rifle Pistol Association versus Bruen. Then the Rahimi case. And now we have a new case. This one's out of the Ninth Circuit. We'll be going over this one. And like I've mentioned before, is that there's a reason behind this. What's the reason? Why is the Second Amendment such a hot topic? And the fact that it's being challenged, any and all legislation regarding the deprivation of that particular right. And then, furthermore, what's actually being elucidated here? Some of my followers that have been following me for quite some time may recall me talking about going back to the common law, the return to the common law, the rule of law, Trump's proclamations, executive orders from 2017, reestablishing the rule of law. Some of his nominations and appointees won to the Supreme Court, but there were several seats that were vacant all through the U.S. In the federal courts, which the president nominates and Senate appoints. And with the instructions to start upholding the Constitution and the Bill of Rights. So this is what's been going on. Again, I want to remind people, under a continuity of government. Okay? So, in a sense, it is government de jure, because the corporation, United States Inc., was involuntarily bankrupted June of 2020. Okay, so when a corporation goes into bankruptcy, they cannot make any new contracts. None. Zero. So, again, there's no such thing as a president right now. Hasn't been since the corporation was taken down. Trump did not concede the election. Again, that bankrupt corporation cannot make any new contracts. So, that whole election is invalid. Period. All right, good evening, folks. Yep. See you all out here. Diesel D's, CC, who's her back guy? You said hi to corruption detector, but I don't see him. I see Diesel D's. I hope corruption detector is doing well. Sadie Cooper out there on YouTube. Third Eye Knowledge. Cat G. Regina Kellum. Good evening. Thank you. There's Jax. I was looking for you. I saw your post there on X, and I didn't like it. I got sidetracked, but I did see it. So there he is. There's Corruption Detector. How you doing, brother? I hope you are doing well. Ah, good things. And back to the rule of law and the instruction to these new judges, and the fact that the corporation cannot make any new contracts. We're under a continuity of government. This is Texas v. White under Article 4, Section 4, the powers that belong to the executive branch. And like it says, not acting as president, but as commander-in-chief, has the power to set up provisional government pending the outcome of the war. Essentially, we've been at war since the Civil War. Does anybody know of a treaty of peace from the Civil War? I'm not. There could be one out there, but I'm not. But let's take a look at the Executive Order 13818. The one I've been talking about since December 20th, 2017, when it first came out. Again, those of you that have been following me that long will recall me going over that executive order when it first came out. Chris and I were talking about it. And I laid it out that, look, what's going on here? Based on some of the other proclamations and executive orders and all this good stuff, this was a World War executive order from the military, because executive orders are commander-in-chief orders. Those are military orders to execute the law for those involved in serious human rights abuse and corruption. It's the takedown worldwide. Now, I showed that one video clip of Jan Halpert, and she was on the English news there talking about this stuff and how over 650 planes it took over 650 military planes to remove all the gold, to pick up all the gold that belonged to us, more than likely in the Vatican, because the Vatican at that time, back then, I was aware of that the Vatican had been raided 6 times. Trump walked in front of the Queen. Trump did the sword dance in Saudi Arabia, which Saudi Arabia was the first that's listed in that Executive Order 13818 as the targets to hit first, Saudi Arabia. So, this all happened. This is all past news. Long time ago now. Vacation was great. Thanks, Jax. It was a good time. Holy crap. We're pretty much the only ones up there, except for some daytimers that were coming in and also looking for morels. And, boy, did we find some morels. Holy smokes. They were a little hard to find, but when we got into, little areas and stuff, man, they were just all over the place in big clumps. Like one clump I had found had 8. My brother found one clump, just one spot had 9, with 2 more off to the side of it. It was crazy, and they were good size morels. The first ones the first day there, we were finding some little tiny ones, medium sized ones. But by the third day, we finally did get in there and find some, and they were, pretty good sized meaty suckers. And we filled basically a 3-gallon bucket full of morels. So it was a good time. Dirt biking. We didn't do any hardcore riding, but definitely got out and ripped it up and got some 2-wheel therapy in there. Rode from we ended up coming in a different way on the mountain, and basically coming out and around a different route, because last year when we tried to get up in there through our normal route, it was snowed in. So we couldn't actually, the place that we wanted to actually go was still snowed in, because we rode the dirt bikes from the one side down and around the lake there, or reservoir, and back up the other side and up and up and up until ran into the snow. So the roads are still covered. Here on Rumble, all caps, false prophet. What bike do I ride? I have an '07 CRF 450R. And last year I had tore the head off and had fancy valves put in it. Had some port work done to the head. And right across the street here at the machine shop, there's a kid that was working there who did a lot of motorcycle stuff. So I had him basically rebuild the head, do the machine work, 5-angle grind on the seat, and I did all the mechanic work, tore it apart, put it back together. She runs like a raped ape, let me tell you. Oh, she's a beast. Yeah, it's good times. We haven't eaten them yet. Actually, my brother's probably ate a few of them by now, but he decided to dehydrate them. So put them through the dehydrator, and they're done now. I need to. I actually have yet to try a morel. One, it's just fun for me to find them now that I can actually see them and find them. Funny thing, a couple of years ago, had hard time even seeing them, finding them, and I'd always wear my sunglasses when I'm outside. It's just something that I had a optometrist when he looked at my eyes back when I was younger, and he's like, "Oh, you burn your." He's like, "Are you a welder?" I'm like, I used to be back when I was building race cars and fabricating and working in a wrecking yard and doing custom exhaust and roll cages and all that good stuff. Well, I'd burnt my eyes a few times because thought I was invincible, and I'll just hide the tip because I couldn't fit, especially on some of them. We did Meridian school buses, did their exhaust work for them, and sometimes it's pretty tight in there. Trying to have a hood on, couldn't really see, couldn't get in there, so I would just do the hide the tip, and yeah, no, horrible. Anybody out there that thinks they can get away with that, I highly recommend you don't. Find something to protect your eyes, because right around midnight, my eyes just started. I woke up with burning sensation, like somebody had dumped a shovel full of rock salt sand in my eyeballs, and all I could do was fumble to get into the bathroom and run my eyes under some cold water. But it's weird that it took that long for it to hit me. But anyway, he told me to wear sunglasses, but that my eyes would heal, because I used to have a hard time seeing at night. Bright lights would give me a headache. Yeah, don't have that problem no more. But I've wore sunglasses pretty much every day since then. We're talking 25 some years ago. So it was weird because I couldn't see him, and took my sunglasses off, and all of a sudden I was able to see him. So it was very weird. But the other part is getting exercise, hiking up and down the mountains. Whew. So yeah, pretty much the one day there we spent, I don't know, I'd say probably 4 to 5 hours out of the whole day that we traipsed around, up around in there. Up and down and around, up and around, and down and around. And still, even up there where there's snow piles, running into piles of snow that haven't melted yet because they're in the shady side of the mountain, and lots of trees around it. Way too much shade for it to get melted off. So yeah. James, good to see you, brother. But I mean, it was campers. There was like, oh, I don't know, 2 or 3 campers up there when we first come in on the one side, and then we dropped down and went back up, and then kind of back down. But the campgrounds, there was 2 camp hosts out of the, I don't know, 5 different major campgrounds up there, and only one of them was actually open. The other campground where the camp host was at, they weren't even open yet. But I saw them sneaking in and out when one time we went by there. Other than that, it was just us. Totally quiet up there, besides from the frogs and the birds and the ravens and deer. Had one deer there really, really close to the campsite. Ran into one out looking for morels. Didn't seem to be too afraid of us, really, till we started talking at it. Then it was like, huh, what? Nope, I'm out. But, yeah, good times getting out there with nature. And, down where I was at, absolute no cell service. Nothing. So I was like relieved of any kind of RF. So again, very, very relaxing. Slept really well. Holy smokes! Wasn't too cold at night. It was just right. It was just right. And got up to about 71, 72 for the high on the one day. Other than that, it stayed right around 68 to 72 for the highs, down to about 45 for the low. It was very good to get back to nature and relax. All right, so back to our continuity of government and what's been going on with Executive Order 13818. Now, there was that one video I shared over here from Twitter, from X. Can't remember what was his name. Rankin. Ivan Raiklin. This guy, Green Beret, Army Green Beret, good guy, seems like, knows his stuff. See how he just rattles that stuff off the top of his head? Okay, he knows. He's got a list of all the deep staters and all that stuff that's going on, okay? In fact, I should really. Let me see if I can play this from here. It's going to take me 2x to play it. Now it's approximately 20 minutes long. And I don't necessarily want to play all of it, but he's talking with some sort of media type person. We'll skip the first little bit here where he kind of grills her about who she is.
So it's on NPR? Well, yeah, it's on public radio, but it's not an NPR program. It's its own company.
Okay. So what is your question? You talked to me before?
Yeah, we met. I mean, it was like 2 years ago. Are you sure? Yeah.
Which Reawaken?
It was the first one I went to was in Nashville. Well,
like, do you get tasked to come down here?
Brought you here.
Ivan Raiklin?
Yes.
Okay. Yeah, because the other one's still censored by Bruen.
So you started a new account?
I have receipts on every single individual. That's why they haven't really come after me yet, because if they bring me in, the entire regime comes crumbling down. Whoa. Okay? Well, so they are scared of me, not the other way around.
That makes more sense. You, on your Twitter bio, I noticed today it said Secretary of Retribution.
Yep. I will guarantee. Yeah, that means that I will guarantee consequences for a list of at least 350 individuals that are on my deep state target list.
So he's got a
And
deep
when you
state
read that
target
deep
list.
state target list, remember, I'm an attorney and a retired
you know,
Green Beret. Okay?
That I know. Well, that I might be interested in talking with you more about is your deep state target list, if
It's,
you have time.
Elon Musk has it. Michael Schellenberger has it. Matt Taibbi has it. The Judiciary Committee has it. The Weaponization Committee has it. The
You gotta listen
Oversight
to what he's
Subcommittee
saying.
that is part of the House Administration Committee has it. The House Freedom Caucus has it. The Speaker of the House, Mike Johnson, likely has it. And it's just a matter of time for a joint press conference to take place between Speaker Johnson and Elon Musk to go ahead and disclose.
Yeah,
Release the
it doesn't
Twitter
matter,
direct
Diesel D's.
messages
He's
of
talking
those
whatever he's
individuals on
talking
my
about
deep
here.
state target list, proving the seditious conspiracy going back to 2016, the illegal spying operation on the Trump campaign. You're also going to find the involvement of Mike Pence and his chief of staff, Joshua Pitcock, in that conspiracy, along with Josh Pitcock's wife, Catherine Seaman, who was the senior Russia analyst for Peter Strzok, who was one of the two individuals that was deployed by Jim Comey and Andrew McCabe to get General Flynn to lie or to get him fired, as per Bill Priestap's notes, which was the Deputy Assistant Director of Counterintelligence at the FBI.
That's a long list.
I can go in much more detail, but that's generally the crux of it.
Do you get to meet with Jim Jordan and talk about this stuff?
I meet with everybody.
All these guys?
Every single member that you think I talk to or may talk to, I talk to them.
And what do you guys talk about?
A lot of people have probably already seen
Everything
this
that
by
I put
now.
out publicly,
Yeah.
I also provide that to them.
But
And I guess
I
what
don't do
mean
anything
is,
behind the sheet, like
Yeah.
behind.
it's
closed
just
doors.
it's just a
Every
matter of
meeting
time,
is
What
folks.
are you hoping to get out of
Right?
talking to them?
It's not
why you do it.
I
necessarily
want to
just
guarantee
this
Elon
man,
Musk
right?
discloses the direct messages for the mother of all Twitter files, so that the entire country can see what just occurred to them starting from the illegal
What he's talking
spying
about, he
operation,
talks about live
the corrupt DOJ,
streaming,
FBI.
the arrests of some of these people. Okay, given the fact that I'm pretty well aware that a lot of people have already been arrested, some of them have been prosecuted and sentenced to prison, some of them have been sentenced to hang, death by firing squad, euthanization, and have already been executed. Okay, so again, I want to reiterate, how does the DOJ want to try to stop Trump from doing executions where he'd already, what did they say? It was like he'd already done, was it 6 or 9 executions? And the DOJ wanted to try and stop Trump from doing any more. How do you stop somebody from doing something if they're not already doing it? It's just like, how do you have a treaty of peace if we're not at war? Many, many, many treaties of peace have been done now. Saudi Arabia was the first one. So, here again, out here on telling, I'll believe it when I see it. Dude, we're not in the need to know. We're just not. This is a military operation. Worldwide. Executive Order 13818. I get people that want to know. I do too, right? I wouldn't mind seeing some of this stuff myself. But we're just not in the need to know. Plain and simple. Again, I've explained this before when I was in the Marine Corps. One of the Marine Corps mottos there is hurry up and wait. Military service members aren't even given full disclosure, aren't even told exactly what's going on. It's all broke down into tiny little bits, and 99.9% of the time, we don't know jack shit about what's getting ready to happen until it's time to go do it. And that's all we know is what little part we're doing. And that's it. We don't know any part of the bigger picture, let alone the whole picture. So get real, folks. You're not in the need to know. I'm not in the need to know. Even with everything that I've got going on and the sources I have, I'm still not in the need to know. So stop trying to dismiss what's happening because, well, you don't see it. You're not aware of it. Well, do you think the fake mainstream media is going to show it to you? No. They won't even show people being, dying suddenly. Do you see any mainstream media talking about that? Crap, they don't. Do you see any mainstream media talking about what I'm going to show you here tonight? About how we're returning back to the laws of nature, the common law, the fundamental law that we're supposed to have, not Roman civil law, the code? No. You have to dig and research yourself. Plain and simple. And even then, you're not going to find any video footage of anybody getting executed. You might see some video footage of certain people getting arrested, like Nancy Pelosi. That one kind of leaked out. She's being arrested by U.S. Marshals. Don't say anything. I won't. Plainclothes U.S. Marshals. Remember when Hillary Clinton was being forced into that SUV? Yep. That's when she was getting arrested. It is and has already happened. There's a lot that has already happened. And like Trump said, he had a really big decision to make. And that this was much bigger than they thought. Okay? And the reality is the decision was does he call in the military, call martial law, and just come in and do what Executive Order 13818 is all about, to take down bad governmental regimes that are actively engaged and involved in serious human rights abuse and corruption. Is there anybody out there that's experienced any of that corruption or serious human rights abuse? I have. Been in the trenches fighting this crap since 1995. Been around a long time, folks, trying to fight this crap. I am not new to the serious human rights abuse and corruption. My first actual foyer and entrance into it was in 1985 when I was the 14-year-old child that had his family ripped apart by CPS, the state of Washington. I know what it's like to be the child. Long time ago, experiencing serious human rights abuse and corruption. So that may be farther back in history and time than some of you are old. But I know a lot of people that are here right now watching, or that may watch later because they can't watch right now, have experienced it. That's why a lot of you are here. Here on Rumble, JG54. Hello, Kirk from New York. I heard an estimated 23 state legislatures proposing gold and silver to be legal tender. It's already in our Constitution. What makes it this different? One, I've already showed the Congressional Act to reestablish the gold standard. That's already happening. We got the whole banking system, essentially worldwide, has switched from the SWIFT system to the QFS, quantum financial system. I've showed that in a previous, couple previous videos, quite some time ago. Things are changing worldwide. I reported on the the three international banks in China that were raided and shut down. That was in 2019? Doesn't we the people have the right to know the enemy? Is it hiding it, aiding and abetting? No. It's a military operation. What is it that people don't understand about that? Military operation. Military doesn't put out their play-by-play of what they're going to do or what they have done. That's just how the military works. Right? I did hear something about that one. Massey's there. He introduced a bill to end the Fed. Well, again, this stuff's already happened. Trump ended the Fed. Moved the Fed or Federal Reserve back under the Department of Treasury. The same thing with the IRS. Okay? Again, military operation. Under a continuity of government, the president, only acting as commander-in-chief, has the authority to set up provisional government pending the outcome of the war. We are at war, folks. Wake up! War. Commander-in-chief has the authority to do all this. It has been done. It's already happened. Worldwide. Again, how do you do a treaty of peace if we're not at war? Why would we be doing treaties of peace? Come on, do some research. Look it up. I've showed it before. Many, 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 many treaties of peace. Explain why Trump walked in front of the Queen. Explain why Trump did the sword dance in Saudi Arabia. What is that symbolism? What does that mean? Symbolizes. Means he's in control. Nobody has ever walked in front of the Queen of England, ever, in history. You'd be executed if you tried to. Straight up. Trump walked in front of the Queen, inspected her so-called military. That was the end, essentially, of the deep state over there, because that's really where it originates. It's all about that Roman Empire. Back to that Roman civil law, the code. And it's much deeper than that, but that is, in my research studies, is what I have found over and over and over and over again throughout history, is the Roman civil law, the code, being implemented. Now, I have finally found it in the Congressional Acts of 1873. That Code of Civil Procedure Act. The same exact one that I found in Idaho legislative session laws of 1881. So in 1873, right after the Reconstruction Acts of 1871, they have altered our fundamental law. It affects the form of government. It's a fundamental law. Blackstone's Commentaries on the Law of England lays this out. There's Roman civil law, the code, there's feudal law, and there's common law as fundamental law. And in Bouvet's Law Dictionary, it talks about the civil law being the Roman civil law, the code, which is opposed to the law of nations, the laws of nature, and the common law. And it's all enforced by what? Bills of pains and penalties. Gee, why is it in Article 1, Section 9, federal prohibition on bills of attainder? Why is it in Article 1, Section 10, prohibition on the states? No bills of attainder. Got to know your history. Got to know the facts of law, the history of law. Why is that there? Because that's what Roman civil law does, the code. Here's the crime. Here's the punishment, whether it's jail time or fine or both. That is code. That is Roman civil law. And this is in part exactly what that Tanawa Downing's doing out there, going state to state, which I did mine for Idaho. The affidavit to the Attorney General informing him of the criminal conspiracy going on. It's basically a criminal conspiracy complaint. Okay? There's something much bigger going on with all that. Okay? And that's putting them on notice, affording them the opportunity to do the right thing, because he's the Attorney General, head of the executive. Well, I guess not head, would be commander-in-chief, would be the governor. But when it comes to prosecuting attorney general, see, Attorney General, which is a military rank. Imagine that. Military operations, military rank, general, who's a prosecuting attorney. Remember, in our form of government, our republic is supposed to be of the people, by the people, for the people. That general, under admiralty jurisdiction, military jurisdiction, is supposed to prosecute on behalf of the people against public servants. Against what? Serious human rights abuse and corruption. That's what they're supposed to do. So, that's what I did for Idaho. And, kind of coincides exactly with my case that I have going right now, that I've already done the notice of appeal, the constitutional challenges, off to the Attorney General. So he's already aware. What a coincidence. What timing. But it's very narrow. What Tanawa is doing is it's in violation of the Fifth Amendment. It's not doing indictments. There's no grand jury indictment here. They're doing prosecutions by information. Well, that's Roman civil law, the code. That's the way that works. So, what has Trump been saying for how long now? The courts are corrupt. Well, it's not just the courts. It's the whole thing. It's the legislative branch, the executive branch, the judicial branch. Because why? It's not a government. It's a corporation. They hijacked our republic during the Civil War. That's what that was really about. Because the debt was paid. That's right. Our national debt was paid. It was time to give back the republic and give back everything they took from us in the first bankruptcy of 1791. And of course, like I've covered for Montesquieu about monarchies, they're all about war. That's all they do. Conquer, war. War and conquer. War and conquer. That's what a monarchy is known for. So, that's what's been happening all throughout history. That one world government, new world order stuff. Been going on for a couple thousand years. So, this is the thing, is I have to understand what's really going on here and how the magnitude of what we're facing. And what 9/11 was really about was another civil war, another attempt at, because the third and final bankruptcy came to an end in 1999. And it was time to give it all back, even though, because see, the Civil War, right? We supposedly lost the Civil War, and we lost our republic. And they're doing the same thing over and over and over and over and over and over and over again. Oh, you lost the war, and you owe us. You have to pay us back. All while the whole while they're funding both sides of the war. talk about enslavement, debt slaves, peonage. It's exactly what it is, guys. So, given all of that understanding, comprehension, I want to show you what's going on here. What did the Supreme Court lay out May 9th? And this was, this was the Ninth Circuit Court. Now, but the first case we're going to touch on is the New York State Rifle and Pistol Association, Inc. et al. Versus Bruen, Superintendent of New York State Police et al. Now, this case takes down all legislation, declares it unlawful and unconstitutional to require the people to seek permission to carry arms. Whether it's concealed or open, it doesn't matter. We do not seek permission to exercise a right. Because what does it say? Keep and bear. We get to keep it wherever we want to keep it. Whether it's in our homes or whether it's in our pocket, whether it's in our bras, underwear, whatever, wherever we want to keep it. And bear. See, well, that's one thing they really haven't talked about. What is the intent of the Second Amendment? Was so that the people were well armed against tyranny. So that we can take down the corrupt. So that's what this case is about. And, you know, they go back to, I'm going to see if I can just do a quick search on that. And go to, let's see if I can find Blackstone. Let's see. All right. From Blackstone through the 19th century cases, commentators and courts routinely explained that the right was not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. Really? Let's see what else we got. How many of them? Does it only show a certain amount here? Let's see. For example, we found it fairly supported historical tradition prohibiting the carrying of dangerous and unusual weapons, that the Second Amendment protects the possession and use of weapons that are in common use at the time. And what are they citing? First citing 4W Blackstone, Commentaries on the Law of England, 148 and 149 from 1769. Then quoting United States versus Miller, 1939. That said, we cautioned that we were not undertaking an exhaustive historical analysis today of the full scope of the Second Amendment and moved on to considering the constitutionality of the District of Columbia's handgun ban. We assessed the lawfulness of that handgun ban by scrutinizing whether it comported with history and tradition. Although we noted that the ban would fail constitutional muster, right? Yep. Under any of the standards of scrutiny that we have applied to enumerated constitutional rights. We did not engage in means-end scrutiny when resolving the constitutional question. Instead, we focused on the historically unprecedented nature of the district's ban, observing that few laws in the history of our nation have come close to that severe restriction. Now, there's another thing here, too, is in this particular case, they've established a new standard of review. They're not using that means-end scrutiny. They're just flat out, does it come in conflict with the right or not? Let's see if we can get into none other Blackstones, because thus our earlier historical analysis sufficed to show that the Second Amendment did not countenance a complete prohibition on the use of the most popular weapon chosen by Americans for self-defense in the home. Let's see. A long, unbroken line of common law precedent stretching from Bracton to Blackstone is far more likely to be part of our law than a short-lived 14th century English practice. Similarly, we must also guard against giving post-enactment history more weight than it can rightly bear. In particular, respondents advocate argue that offensive arms in the 1600s, 1700s were what Blackstone and others referred to as dangerous or unusual weapons. Brief for professors of history of law, as Amica Curie said, quoting 4 Blackstone commentaries 148 through 149. And again, why are they, again, Blackstone, commentaries on the law of England. Comes from the laws of nature is what it ended up coming down to here. And this is the case that really hammers it home that it comes from the right of self-defense. But see, they're not talking about what the right's really about. Are they? They're just saying that, yes, we have the right to keep and bear arms. Respondents there in their dissent all misunderstand these statutes, and the dissent all misunderstand these. Far from banning the carrying of any class of firearms, they merely codified. Here's that codified the existing common law offense of bearing arms to terrorize the people, as had the Statute of Northampton itself. So it's about, yeah, right there. Going armed offensively in fear or affray, which is basically attacks, of the people, indicating that these laws were modeled after the Statute of Northampton to the extent that the statute would have been understood to limit public carry in the late 1600s. Moreover, it makes very little sense to read these statutes as banning the public carry of all firearms, just as few years after Chief Justice Holt and Sir John Knight's case indicated that the English common law did not do so. But see, that's the difference between Roman civil law and the code and common law. Regardless, even if respondents' reading of these colonial statutes were correct, it would still do little to support restrictions on the public carry of handguns today. And most respondents can show that colonial legislatures sometimes prohibited the carrying of dangerous and unusual weapons, a fact we already acknowledge. Now, notice the word prohibited here. That's what? That's not mala in se, that's mala prohibita. And whose conduct can we actually prohibit? Public servants. We, the people, have all the power. We can prohibit their conduct. We cannot prohibit the conduct of our neighbors. See, Hale versus Hakel, we're in the private. We have no duty to open our books and papers on suit of the state or to our neighbors. We're in the private. We're not in law. We're at law, at common law. Drawing from this historical tradition, we explain that the Second Amendment protects only the carrying of weapons that are those in common use at the time, I think. At the time, as opposed to those that are highly unusual in society at large. Okay, so we wouldn't want people running around the street with cannons pointed at buildings or cars and other buildings, other people. Okay, that's would cause some fear now, wouldn't it? But a man walking down the sidewalk in front of your house carrying a pistol or a rifle, how would that scare you? Cause fear? It shouldn't cause any fear. None. In fact, you should feel more safe. In the rare event they're there to rob you, well, then that would be a different story. But contrary to mainstream media propaganda, that's a very rare occasion. Unless you're in certain designated areas, that if we were to eliminate those areas, our so-called crime rate with arms would be almost nothing. So you might want to take a look at certain particular areas that have an extremely high crime rate involving arms. And I'm not going to go so far as actually blame them, because they've been forced to live like that. Stacking people on top of each other and having mass amount of people in a very small area. What do you expect? Thursday invoked in the response was enacted in East New Jersey in 1686. It prohibited the concealed carry of pocket pistols, or other unusual or unlawful weapons, and it further prohibited planters from carrying all pistols unless in military service or, if strangers, when traveling through the province. An act against wearing swords. In Grant's Concessions, original Constitution province of New Jersey, in 1881. Imagine that, Reconstruction Acts of 1871. These restrictions do not meaningfully support respondents. The law restricted only concealed carry, not all public carry, and its restrictions applied only to certain unusual or unlawful weapons. See? Now, pay attention. Carrying concealed unusual or unlawful weapons, including pocket pistols. It also did not apply to all pistols, let alone all firearms. Pocket pistols had barrel lengths perhaps 3 or 4 inches, far smaller than the 6-inch to 14-inch barrels found on the other belt and hip pistols that were commonly used for lawful purposes in the 1600s. But we're not talking about necessarily the 1600s. Moreover, the law prohibited only concealed carry of pocket pistols. It presumably did not, by its terms, touch the open carry of larger, presumably more common pistols, except as to planters. In colonial times, a planter was simply a farmer or a plantation owner who settled new territory. Using the records of the East and West, let's get back into some more of that. Blackstones. For Blackstone, not meant as any degree of punishment. Citing at 249, the burden of these surety statutes that may have been on the right of the public carry was likely too insignificant to shed light on New York's proper cause standard, a violation of which can carry a 4-year prison term or $4,000 fine. Bill of attainder. But in Heller, we noted that founding era laws punishing unlawful discharge with a small fine and forfeiture of the weapon, not with significant criminal penalties, likely did not prevent a person in the founding area from using a gun to protect himself or his family from violence, or that if he did so, the law would be enforced against him. But see, this is right here. A violation of which, see, Bouvet's Law Dictionary under Bill of Attainder says legislation, punishment. There it is. It's legislation that creates punishment. When where's the victim? Where's the injured party? There is none. There's no standing, no cause of action. Okay. Yeah, I want black stones. commentaries in the courts routinely explained that the right was not a right to keep and carry any weapon whatsoever in any manner whatsoever for whatever the purpose. Oh, I guess it went all the way around. Because what page is that on? No, it's on page 81. Okay. Keeping carry whatsoever in any manner whatsoever for whatever purpose. Nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. Footnote 26, we identified these presumptively lawful regulatory measures only as examples. Our list does not purport to be exhaustive. But, interestingly enough, arms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings. What? Why is that considered a sensitive place? Good to see you, brother Art. Yeah, but you're talking about code. Pursuant to the 1934 Federal Firearms Act, which is all Roman civil law, the code, says that rifles, shotguns, and pistols, rifles, and shotguns are not firearms. Firearms are only guns that have been... They're not called firearms. They're called arms. The right to keep and bear arms shall not be infringed. This is an infringement on the right to keep and bear arms. It doesn't state which kind of arms. Any. And again, I could give a rat's ass about what code says. We're looking at the right. What law says. But the fact is we're going to look at that real quick here because that's the case. Now, the Rahimi case, this is the one that they had to wait until the Supreme Court, and this was out of Texas, the Fifth Circuit Court of Appeals, this is federal, and they had to wait for the Bruen case for the Supreme Court to rule on that, and then they struck down, in this particular case, they struck down the legislation regarding code under the Domestic Violence Protection Act, protection orders, and there were you have to go turn in your arms. You have to turn in your guns to your local sheriff. Nope, unlawful and unconstitutional. Now, again, this guy here, Zachary Rahimi, if there's ever a poster child for somebody who should not have arms, if we're going to say that certain people shouldn't, this guy is a poster child, okay? But they still said no. No, he has every right to keep and bear arms. Now, let's get into the United States of America versus Stephen Durte. Hope I pronounced that correctly. This guy's got 5 felonies. Uh-oh. Versed in the district court's judgment, the panel vacated Stephen Durte's conviction for violating 18 U.S.C. 922 G1, which makes it a crime for any person to possess a firearm if he has been convicted of an offense punishable by imprisonment for a term exceeding 1 year. So, felony. On appeal, Durte challenges conviction on Second Amendment grounds, which the panel reviewed de novo rather than for plain error because Durte had good cause for not raising the claim in the district court when the United States versus Voxney, blah, 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 foreclosed that argument. So they just ex-nayed this case. So anybody who ever wanted to try and cite that case, you can no longer cite that case because, which was from the Ninth Circuit, 2010. So again, I want to reiterate what's going on here. They're taking this crap down and they're overturning previous cases. Now, what are they saying here? The panel held that under New York State Rifle and Pistol 2022, 922G1 violates the Second Amendment as applied to Duterte, a non-violent offender who has served his time in prison and re-entered society. And that Vanze, whatever, which did not apply the mode of analysis that Bruen later established and now requires courts to perform, is clearly irreconcilable with Bruen. Uh-oh. Applying Bruen's two-step text and history framework, the panel concluded Duterte's weapon, a handgun, is an arm within the meaning of the Second Amendment text. That Duterte's proposed course of conduct carrying a handgun publicly for self-defense falls within the Second Amendment's plain language. Shall not be infringed. And Duterte is part of the people whom the Second Amendment protects because he's He's an American citizen. And the government failed to prove that 922G1's categorical prohibition, as applied to Duterte, is part of the historical tradition that delimits the outer bounds of the Second Amendment right. See, now they're going through, again, that's the new analysis. They're going through a historical tradition. Huh. Imagine that. But see, we're talking about real law and not code. That historical tradition. What are the rights? The law, not the code. But again, I'm challenging this code, folks. That's already been challenged in my case right now. So the fact is, they've altered our fundamental law back to the Declaration of Independence. That's what happened. That's what was, again, doing the same thing over and over again. In fact, I might actually have that sucker pulled up right now. Let me see. Is it this one? Yeah, we'll certainly do. Let me pull this sucker over here so we get a better understanding what I mean by this. See, these are the declared acts of tyranny, right? To prove this, let facts be submitted to a candid world, and that they're declaring what? Declaring the causes which impel them to the separation. These are declared acts of tyranny or of a tyrant. These are characteristics and conduct of a tyrant, which are declaring this as our enemy. Tyrants are our enemy. And these are characteristics and conduct of a tyrant. So giving aid to our enemy is treason. So if you start acting like this, you're a tyrant. You're committing treason. Oh, let's see. How about that? He has erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substances. Imagine that. But that ties into he has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, given his assent to their acts of pretended legislation. That's the Roman civil law, the code. It's a jurisdiction, a body of law that is foreign to our Constitution. It is unacknowledged by our laws, common law. Not statutes, because statutes are not law. They're statutes. That's it. So, How about the next one down here? For abolishing the free system of English laws in the neighboring province, establishing therein an arbitrary government, and enlarging its boundaries so as to render it once an example and fit instrument for introducing the same absolute rule into these colonies. Roman civil law, the code. For taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our governments. It's the same thing again. 1871 Reconstruction Acts. How about for suspending our own legislatures and declaring themselves invested with the power to legislate for us in all cases whatsoever? Because that's how the Roman civil law, the code, works. Under a monarchy, the king dictates. Parliament. But mostly the king. Well, the thing is, Brother Art, there are no statutes. It's all code. There are no statutes. Hasn't been since 1873. He has abdicated government here by declaring us out of his protection and waging war against us. Gee, why is that? Domestic violence in Article 4, Section 4? That's right. Even though they want to, Congress created that Violence Against Women and Children Act, VAWA, of 1995, which parts of it in U.S. versus Morrison was declared to be unconstitutional. But the fact is, and I like how law.cornell.edu has changed their verbiage in there after I've exposed the fraud there, that Congress exceeded its authority by redefining what domestic violence is pursuant to Article 4, Section 4. They call, well, in the now archaic terms of domestic violence is internal insurrection. But the modern term for, the modern English of domestic violence has to do with domestic relations, family units. And no, Congress doesn't have the authority to redefine any part of the Constitution. We, the people, are supposed to have made the Constitution. You don't get to just interpret the Constitution how you want to interpret it. And what it means, the definition of those words, this is exactly what's going on here with the Second Amendment and what they're doing. Is they don't care about any of that stuff. In the Bruen case, the New York State Rifle Pistol Association versus Bruen case, the Supreme Court was talking about telling all these members of the bar over there trying to make all these arguments about, well, this statute here in history says, this statute, and this case law over here says, and the Supreme Court justice said, well, look, we don't care about any statutes. We don't care about any case law. We want what? We want the historical tradition of the Second Amendment. What did the Second Amendment mean by the founders who wrote it at the time it was written? Now, again, remember, what did we had just go through? A revolutionary war? Tired of tyrants and tyranny? That absolute despotism? That absolute rule over the people? But interesting enough, Hale versus Hinkle reiterates this, is that our rights are long antecedent to the formation of the state. But the fact is I was reading in Federalist Papers from Alexander Hamilton about what he wrote in there about not having a Bill of Rights, that we didn't need a Bill of Rights because Bills of Rights are for kings. Our rights, we are common law. We already have all these rights. It's the common law. It's already the law. That's the thing about all this, folks. It's already the law. Lex non scripta, the unwritten law. It doesn't need to be put down in writing. But the thing is it's a good thing that they did. Because if there wasn't a Bill of Rights, we wouldn't be having this argument made right here. But I can tell you right now, if the code, Roman civil law, goes away and we actually seriously return to the common law as a fundamental law, all of this stuff goes away. No more bills of attainder. No more bills of pains and penalties. None. Because, see, the jury is supposed to determine the punishment at common law. How many of you knew that? How many of you knew that the jury is supposed to determine how much the damages are? They do that in like Title 42 1983s and other similar lawsuits like that. When you say civil, the jury gets to determine how much it is. So there's a sliver, right? There's a sliver of it left from history where the jury gets to decide the punishment. But when they go criminal, per the code says 922G1 is 5 years prison time and up to a certain amount of time in jail. That's a bill of attainder. But then they say, oh, Kirk, but bills of attainder were for felonies and they were depriving them of their right to trial by jury. That's a lie. Well, it's a half-truth. It's still a lie. It's not just depriving the right to a trial by jury. You've been attained to pay this bill. And it's a form of human trafficking, debt slave, peonage. Because who gets the fine? They do. And they all split it up amongst themselves. Where's the victim? Where's the injured party? Do they get any of that so-called fine? Well, there isn't one. And then even if there is one, no. They don't get any of that fine money. Huh. Well, I'll be darned. Why is that? Desmond dissented. He wrote that until an intervening higher authority that is clearly irreconcilable with Fonse's handed down, a three-judge panel is bound by that decision. He wrote that Bruen, which did not overrule, reiterates that the Second Amendment belongs only to law-abiding citizens, and that Durte's Second Amendment challenge as applied to nonviolent offenders is therefore foreclosed. But this is the dissenting opinion. Okay? Everybody else, well, the other two, overruled. But more than likely this will get appealed to the Supreme Court. But still, it's being struck down even for felons. If it's non-violent. But see, this is, again, nobody's challenging personal jurisdiction. Nobody is challenging subject matter jurisdiction. Where did we give Congress subject matter jurisdiction? And then Where did we give them Congress personal jurisdiction over man in the private? Hale versus Henkel, just, laws of nature that were supposed to be in the private. And then the big kicker, territorial jurisdiction. Article 1, Section 8, Clause 17 limits the territorial jurisdiction of federal, national government and any congressional act, legislation, is to that 10-mile square. And at forts, magazines, ports, which is supposed to be all under military law, admiralty jurisdiction, and out on the water. That's it. Where else can it apply? It can't apply anywhere else, because how can it apply in the state? Because then that would violate separation of powers doctrine. Well, the state has the power. Or it's like, no, you're limited in your territorial jurisdiction, federal government, national government, Congress, which are supposed to be delegates selected by the state's legislatures and sent for a specific purpose to make certain legislation. We're not actually supposed to have a sitting, elected House of Representatives in Congress. But again, this is all about fundamentally altering our form of government. And again, it's not a government. It's a corporation. It's not a legitimate government, and hasn't been, essentially, even clear back to the War of 1812. And even the first Constitution of 1789. It's a fraud. Read that. Documents illustrated with the formation of the Union in the American states. Namely, the main part to read is that secret debates and proceedings, or proceedings and debates in Congress at the time, and they openly admit that they are exceeding their authority and altering the Articles of Confederation. That they shouldn't be doing that. There were several people that were there that said, no, I'm not going to sign off on this Constitution because we've exceeded our authority. Then they even made the argument that, well, why don't we just do what we're supposed to do here, which is to make amendments to the Articles of Confederation to regulate foreign commerce, which is the resolution passed by Virginia, subject matter jurisdiction. And then what we can do is we can propose to the people another convention for all these other issues that we think we have. And what their response was, nah, we're just going to go ahead and do it because this may be the only chance we get. What does that tell you? A bunch of corrupt POSs in there. Okay? Again, from the crown. Because they really couldn't handle the fact that we wanted to separate from them. But you got to understand who they are. They're a bunch of sick Satanist pedophiles. Right? They want world domination, world control, monarchy, war. They're all about war. It always has been. Right? Don't forget the word esquire. Because that's what they are, esquires, holding that title of nobility of esquire. But see how they're all arguing about case law and arguing about code. Where did we give them personal, subject, and territorial jurisdiction? Well, that's what I've challenged in mine, folks. Gonna have a big old showdown, let me tell you. Gonna be quite interesting. But here's the opinion here. It makes it a crime for any person to possess a firearm. See, but it's not a firearm, it's arms. So they're not even used the proper terms, but if he has been convicted of an offense punishable by imprisonment for a term exceeding 1 year, who has 5 prior non-violent state criminal convictions, all punishable for more than a year, was charged and convicted under after Pole Ice saw him toss a handgun out the window of a moving car. He now challenges the constitutionality of his conviction. He argues that under the Supreme Court's recent decision in New York State Rifle Pistol Association v. Bruen, 2022, violates the Second Amendment as applied to him, a nonviolent offender who has served his time in prison and re-entered society. We agree. Okay. Now let's take a look at, because they list the 5 felonies he's got. We reject the government's position that our pre-Bruen decision in the United States forecloses due to a Second Amendment challenge is clearly irreconcilable with Bruen and therefore no longer controls because Von Zene held that 1902 G1 comported with the Second Amendment without applying the mode of analysis that Bruen later establishes and now requires courts to perform. Do you see the change, folks? It's all trickery. So, if the Second Amendment's plain text protects the person, his arm, and his proposed course of conduct, it then becomes the government's burden to prove that the challenged law is consistent with the nation's historical tradition of firearm regulation. But that's what the Second Amendment did. It took away the power to regulate it. It shall not be infringed. There is absolutely no delegation of power. Where does it say, and Congress shall have power to make appropriate legislation regarding the Second Amendment right to keep and bear arms, which shall not be infringed? Now, for those of you who don't understand what I just said there, let me make it very clear. I'll show it to you what that looks like. Look no further than the fraudulent 14th Amendment. Right here. The Congress shall have power to enforce by appropriate legislation the provisions of this article. I don't see that verbiage after any of those other articles, because they are to be articles in addition to an amendment to the Constitution. The whole Bill of Rights was an amendment. They are not amendments. They are articles. So, the thing is, there's the verbiage that's missing under the Second Amendment, or Article the Second. There's no delegation of subject matter jurisdiction. And just like American Jurisprudence, Volume 16, Constitutional Law, Section 100 says that bills of rights and those merely declaratory of the common law are, those provisions in there are mandatory. And unless there is this kind of verbiage there that gives Congress or the state legislature the authority to make legislation regarding that particular subject, it's done. There is no delegation of power. There is no delegation of subject matter jurisdiction. That's how that's supposed to work under constitutional law. Even Blackstone's Commentaries on the Law of England lays this out in his commentaries. That subject has to be expressed in the Constitution. If it is not, then the Parliament or legislature does not have any authority to make any legislation. That's how that works. But see, what the bar, these esquires, have twisted is, well, the Constitution doesn't say we can't, but it doesn't say you can. But see, it's all about trickery. Well, we went to law school. Yeah, you were taught Roman civil law, the code. I got one of your law school books. It's called Code Pleading. Imagine that. Huh. So, well, good to see you, Mark, brother Mark, out here on YouTube. The thing is it's all under Roman civil law, the code, the courts. I mean, the whole thing. Again, it alters the fundamental law, our form of government. Again, it's a corporation. It's no longer a government. People need to fully grasp this concept. And like I said before, okay, it's like government in a box. Okay, Amazon delivers you this box, and it's a government in a box. And you open up the box, and what do you have inside? You have the fundamental law. It's called Roman civil law, the code. That's part of a monarchy form of government as a fundamental law. Now, let's grab a different box. Amazon's delivered another box, a government in a box. A republic, which is by the people. The people have all the power. Not the king, not parliament. You know, as it is written, all political power is inherent in the people. Not American state nationals, not anything other status or term. It's people. The people is the proper status. Of the people, by the people, for the people. That's a republic by the people. Okay? And in our republic, the fundamental law is the common law. And what goes along with the common law? The law of nations, or the law of nature. That's all part of the common law. Maxims of law and customs is what the real common law is. Not stare decisis. Even though they really push that, even Blackstone talks about how that's all part, becomes kind of part of the common law, is when they make that decision saying, oh yeah, you do have that. Wait a minute. Why would we let the so-called judicial branch decide for us what our rights are and whether we have these rights or not? Again, that's how the monarchy works, not how our republic works. Where in the judicial branch sections did we delegate the judicial branch to make law? Can anybody point that one out? I may have missed it, given the fact that I missed the part in Article 3, Section 2, which is actually part of the 11th Amendment, that, see, this is going to show you right here exactly what Tanawa is doing, and I'm glad that he did. Okay, so we're going to look at the Fifth Amendment first, real quick. Article the 5th. No person shall be held to answer for a capital or otherwise infamous crime unless, what? On a presentment or indictment of a grand jury, except, so here's the exception to that rule of law, except in cases arising, what? In the land or naval forces or in the militia when in actual service in time of war or public danger. Okay, so like I've explained this before, what is an otherwise infamous crime? Now they want to say anything to do with more than 6 months jail time or $1,000 fine. Now, the thing is what do we go by now? Oh, felonies and misdemeanors. But see, why doesn't it say no person shall be held to answer for a felony or otherwise misdemeanor unless on presentment or indictment of a grand jury? Why are we using words like felony and misdemeanor versus capital or infamous crime? It's trickery. One's Roman civil law, the code. Those are bills of attainder, bills of pains and penalties. The Roman civil law, the code, as it says in Bouvet's Law Dictionary, is all enforced by bills of pains and penalties. All of it. Because that's how the code works. The king or parliament makes this a crime, and here is the punishment for that. Yeah, James, let's take that misdemeanor word. Your demeanor is off. Well, who gets to determine our demeanor? Well, that's Catholicism, the church. That's how the monarchy works. Okay, so now that we understand, comprehend, and then understand that the only way that anybody can be prosecuted is either a presentment or indictment of a grand jury. That's what the letter of the law, the right, dictates. You see, again, right and law are synonymous. It comes from the French word droit, meaning right or law. Rights are the law. The common law. Merely declaratory. Bills of rights are merely declaratory of the common law. Imagine that. It's already the law. Again, already the law, but not under Roman civil law, the code. See, that's that 14th Amendment. See, people don't understand what really happened there. The fake so-called 14th Amendment. Privileges and immunities. Where does it say rights? But all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States, not United States citizens, citizens of the United States, and of the state wherein they reside. So you could be a citizen of the United States and a citizen of a state at the same time. No state shall make or force any law which shall abridge the what? Privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law. Well, there's a due process clause, due process of law clause. No. But see, it says privilege. Where does it say rights? And again, I want to reiterate this. The original intent, allegedly, behind this the original intent behind this alleged 14th Amendment was for the recently freed Negro slaves. But now let's look at the real deal here. Article 3, Section 2. Which was what's going on? Let's see. Between citizens of the same state claiming lands under grants of different states, between a state or the citizens thereof, and foreign state citizens or subjects. So, here it is. What is it? In all cases affecting ambassadors, other public ministers, consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. I missed that one. But then it says, in all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact. Uh-oh, does that mean that the jury gets to judge the law and the fact? This is Article 3, Section 2. Imagine that, folks. So, isn't it, like in my case, State of Idaho versus Kirk Pendergrass? Sure is. That's the case style. So, none of the state courts would have jurisdiction. I mean, that's a conflict of interest to begin with, but my argument's a little bit different in the fact that it's a corporation, and that the state of Idaho does not have personal jurisdiction over man. In fact, they have no authority to bring an action at all, ever. Maxfield versus Levy. A fiction can never obtain jurisdiction, because the fiction cannot take the stand, cannot be sworn in under oath. It cannot speak. It doesn't have a mind of its own. It does not have a conscience of its own. It is not among the living. So it can't think, it can't speak, it can't stand. Therefore, it cannot obtain jurisdiction. The Idaho Constitution says it must be in the name of the people as a party. So it's supposed to be one of the people against a public servant or public entity, public, for a public offense, denominated a criminal action. So, oh, good question out here. Very good question. This is really hard for a lot of people to comprehend. What is the difference? And thank you, Stephen Hoffman over here on Telegram. What is the difference between a citizen of Idaho versus one of the people of Idaho versus a person of Idaho? Okay, so technically speaking, lawfully speaking, Law of Nations, Book 1, Chapter 19, subsection 212, defines what a citizen is a member of a civil society. I'll just pull it up and show it, even though I know it off the top of my head, who is bound to perform certain duties and is subject to its authority. So that's a citizen. Then one of the people are inhabitants, or a different kind of citizen, one of the people, because all political power is inherent in the people. And again, Law of Nations, Book 1, is it right there in the very beginning? It's Book 1, Chapter 1. Is it Section 3 that talks about the sovereign are the ones that have the power, the people. So the people are the sovereign body politic. So the people are essentially, and I know this is the hard pill to swallow here, are the business owners, the ones that pay taxes, that pay the bills to fund government. That's how you get political rights, political standing. And then persons, there you go. The business, the fiction, that's the person. Like Kirk's Law Corner LLC is my person. Taxpayer. Idaho Notary Public, that's a person. Governor is a person. Lieutenant governor is a person. A representative, a senator. Those are persons. So that should clear that all up right there. Pretty simple. From the letter of the law. What it says as it is written. But see, that's law of nations, which the code is opposed to. Again, two different jurisdictions, two different bodies of law. Different box of government. In this box over here, you got Roman civil law, the code. Over here, in this box, you got law of nations, laws of nature, and common law. In this box over here, you got feudal law, the feudal system. You got monarchy, you got republic, and you got democracy. That's the difference between a form of government. And ours is a confederate republic. So, that's what Law of Nations says as it is written, the definitions of those terms. And that's the capital C, by the way, in proprietary persona. Right? Because that's what that means. In their proper person. And I love going to the English Bill of Rights of 1689 and showing this. Because it's like people think I'm stupid, crazy, whatever. That I don't know what I'm talking about. But then, you read something from history here, right? Why is this not? There we go. Right here, talking about an act declaring the rights and liberties of the subject and settling the succession of the crown. Whereas the Lord Spiritual and Temporal Commons assembled at Westminster lawfully, fully and freely representing all the estates of the people of this realm, did upon the 13th day of February in the year of our Lord 1688, old style date, present unto their majesties. Listen carefully, folks. Then called and known by the names and style of William and Mary, Prince and Princess of Orange, being present in their proper persons. In propria persona. The name is William and Mary. The style, the person, the proper persons, is Prince and Princess of Orange. That's the person. Just like the Fourth Amendment. What does it say? It says the right of the people. The right of the people to be secure in their persons. That's your business. That's what it says. The right of the people to be secure in their persons. Which goes back to the Fifth Amendment. No person shall be required to answer to any capital or otherwise infamous crime. No person. That's because we're supposed to have suits at common law in the private between man and man. But the right of the people to be secure in their persons, so your private business, Hill versus Hinkle talks about that, houses, papers, and effects. See, people and persons, name and style. Like I'm one of the people of the territory of Idaho. I'm Kirk. That's my name. That's my God-given Christian name. Oh, gee, think I'm crazy. Blackstone's Commentaries on the Law of England lays that all out too. Imagine that. And then in my person is Kirk's Law Corner LLC. In my person as Notary Public. I have the right to be secure in those persons. From what? Against unreasonable searches and seizures. And it shall not be violated. And no warrants, plural, shall issue, but upon probable cause, supported by oath or affirmation. And particularly describing the place to be searched and the persons or things to be seized. Uh-oh. Uh-oh. Doesn't say man, says persons. Huh. Imagine that. Right? Absolutely. Brother Mark out here on YouTube. Madison's Federalist Papers 43 and 45 states we are a Confederate Republic. The Confederation of the States, a union, right? Because that's what a union is. I don't know who this is. McClum 77 on YouTube. Wasn't it only be at most a $20 fine? No. You're talking about suits at common law where the value exceeding $20, the right to a trial by jury shall remain preserved, and no fact tried by a jury shall otherwise be re-examined in any courts of the United States except for pursuant to the rules of the common law. So, but they really want to say that suits at common law are only civil. I beg to differ. Why is it we have the right to demand the nature and the cause of action? And then they say, the Seventh Amendment is to ensure the right to trial by a jury in civil cases as in criminal. Well, where we only have two things. Oh, let me just go right here. We're right here. All right. Article 3, Section 2, Federal National Constitution. The judicial power, so here's the power being granted, shall extend to all cases in law and equity. So that's in law and in equity. And what's in here? About lands, equitable interest in land. Okay? And this is in law. In law. This is in suits at common law. One is in law, the other is at common law. Two different bodies of law. But see, they want to trick us. It's all trickery. Plain and simple. Do you know the difference between a suit at common law and a suit in law? What? To all cases of admiralty and maritime jurisdiction. What other cases are there? I mean, if you're talking about to all cases affecting ambassadors, other public ministers and consuls, okay. But it's a suit in law and in equity. So what's the difference? Do we know? In-law is incorporated into the body politic. So any member, because see, that's Article 6, Clause 3, which coincides with the definition of a citizen from the Law of Nations. Oh, and before we go there real quick, let's look at that. Right here in the Constitution, because people say, oh, well, the Law of Nations, no, that's not law. That doesn't have anything to do here. Then why is it in Bouvet's Law Dictionary, 1856, says that the Roman civil law, the code, is in direct opposition, is opposed to the Law of Nations, the laws of nature, and the common law. But here it is, right here in Article 1, Section 8. Should have went to just 8. Where is it? Right here. To define and punish piracies and felonies committed on the high seas and offenses against the law of nations. This is the power delegated to Congress to define and punish piracies and felonies committed on the high seas and offenses against the laws of nations. So you can't tell me that the law of nations isn't recognized as a body of law per the Constitution, because it's written right there. So, when we go to Article 6, Clause 3, and we go to Book 1, Chapter 19, Subsection 212 for the definition of a citizen, I should just pull that up again just because I'm right here. What's going on here? Thank you. Oh, because I was still in that. Did I put it in here? No. Oh, good. I remembered. It's right here. Section 212, right here. Book 1, Chapter 19, Subsection 212. The citizens, right? This is citizens and natives. So the citizens are the members of the civil society, bound to this society by certain duties and subject to its authority. They equally participate in the advantages. Well, that's the emoluments. Any advantage, profit, or gain received due to one's position of employment or holding of office. This is also where the definition of natural-born citizen comes from. Anytime you're out there looking, in the Constitution about requirement to run for the office of president, you got to be a natural-born citizen, which Obama was not. And it says, see Vattel. This is where it's telling you to go look. Section 212 from Vattel. It'll say Vattel 212. This is it. This is where our founders wrote from the Law of Nations, and the words from the Law of Nations is in the Constitutions. Because this was the law, the written law. Now, who are the citizens again? Oh, they're the members who are bound. Now, when we go look at Article 6, Clause 3, you're going to see this. What does it say? The senators and representatives before mentioned, and, so this is and, the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be what? Bound by oath or affirmation to what? Support this Constitution. Where does it say they have the power to interpret the Constitution? Nowhere. They are to be bound to support this Constitution, not interpret it, not to subvert it. So, basically what this is saying is exactly what the Law of Nations already says, who a citizen is. They are the citizens. We're either an inhabitant or one of the people. Those are the three statuses we have in our republic. Citizens, which are the public servants, whether elected or appointed into position of public trust, because they're a member of the legislative branch, the executive branch, or the judicial, both of the state of the United States and of the several states. It doesn't matter. Because this goes back to the maxim of law that there's no firmer bond among men than an oath. This is why it's required to have an oath. Not only that, in the Bible there talks about, and this is misconstrued, people say, oh, I don't swear, I'm not taking an oath, I'm not taking an oath. Well, because Jesus told not to take, it says, lest you be judged. This is so that we can judge them. That's why we require the oath, to form the bond between men. That's the bond. Not this surety bonds and all those other shit made up under the code. Is you're supposed to have land. See, this is why it talks about dispute with land and all that stuff, right? Equitable interest in the land. That's why you got to have them qualifications. You read some of the early constitutions, you had to own a certain amount of land in order to qualify to run for office. Because that's what we took from you when you usurped your powers or was involved in maladministration, misfeasance, or malfeasance, and trespassed the law. And then we ran you out of town, burned your house down. Ran you out of town, exiled you. I did see that question out there on YouTube regarding that particular part of the Bible where Jesus tells us not to supposedly take an oath. Well, again, that's been misconstrued because people aren't reading the probably just aren't reading it at all. It's all just by word of mouth. Some so-called law guru out there is telling you, oh, I don't take an oath. I won't swear under oath because Jesus told us not to swear. But it's lest you be judged is the other part of the scripture of what Jesus told us. Now you have to make sure you get into some of the Bibles that have it where it says lest you be judged, because others twist that word to try and diminish the meaning, but that's it. So basically, think about it like this. This is part of the reason why in the olden days, and even today even, is some people will not swear under oath to testify as a witness to some sort of a crime for fear of retaliation. So they couldn't be judged. They didn't swear in as a witness, and they didn't testify to anything. Mostly out of fear, especially when it went against the king or the king's men. That's that absolute despotism, terrorism. You want to talk about terrorism? Whew. So, just wanted to let people know about this case here. This is the third one now. And this is, dwindling it away at all of their trying to deprive people of their right to keep and bear arms. We must therefore reconsider the constitutionality, this time applying Bruen's two-step text and history framework, as it is written from the text in history. At step 1 of Bruen, we easily conclude that Duterte's weapon, a handgun, is an arm within the meaning of the Second Amendment's text, and that Duterte's proposed course of conduct, carrying a handgun publicly for self-defense, falls within the Second Amendment's plain language. 2 points the government never disputes. Imagine that. That the people in the Second Amendment excludes felons like Duterte because they are not members of the virtuous citizenry. We do not share that view. Bruen and Heller foreclosed that argument because both recognized the strong presumption that the text of the Second Amendment confers an individual right to keep and bear arms that belongs to all Americans, not an unspecified subset. And that's the thing. Does the Second Amendment say the right of the people to keep and bear arms shall not be infringed except for felons? No. And in fact, the Criminal Practice Act of 1864 in the first legislative session of the Territory of Idaho specifically states, once you're done with your time, you get all of your rights back. I'm going to learn how to be an amicus here, because these people are not making the proper arguments. I mean, they're coming to a good conclusion, but let's beat it out. You don't have any authority to deprive fundamental rights. None. Wasn't ever delegated. No personal jurisdiction over man, no subject matter jurisdiction over any of our rights. Again, American Jurisprudence, Volume 15, Civil Rights, Section 2. Natural rights and civil rights have absolutely nothing to do with the establishment, support, or management of government. You mean, you wait a minute. Let's go back to the intent of creating government. That to secure these rights, governments are instituted among men, receiving their just powers under the consent of the governed. What was the intent of creating government to begin with? To secure our rights as the law of nature, the common law, the law of nations. I mean, let's get back to some basic fundamental principles, folks. Pretty simple, pretty easy. Keep it simple, stupid. Let's keep it so simple it's stupid simple. Right? Yep. They want us to be confused with an outlaw. Those are vagrants or vagabonds. But an outlaw is not bad because, well, they don't settle anywhere. They don't set up a residence. But that's a controversial word too, because the code twists that word, but the law of nations uses residence. That's right. It's a lawful term. It just depends on what body of law you're citing from and the definition what it actually means. But it's in the Constitution as a requirement that you're not supposed to, for certain offices, like congressman, a senator, representative, okay? You can't be a resident. What they're actually saying, what this meant there, that you have to work your way up the chain of command. You don't get to just jump into Congress. You got to have some experience down here. So, with that, folks, we're going to call it a night, but yeah, it's pretty clear that they're hammering out the Second Amendment and they're declaring unlawful and unconstitutional all of this stuff. But they've done this two-step analysis. Is text and history. Show me the text, show me the history. What the meaning of it is from history, not from any statute or case law. From law. Because remember, statutes are made by them, the servants. That's color of law. It's not law. Per their own code, 18 U.S.C. 241 or 242 there, acting under color of law is statute. Oh, that's right. But they're not statutes. It's all Roman civil law. It's all code. 18 U.S.C. United States Code. See, code. Code of Federal Regulations. Uniform Commercial Code. It's all code. Roman civil law. That's that jurisdiction foreign to our Constitution, unacknowledged by our law. Common law. It's unacknowledged by it. Just like Roman civil law, the code does not acknowledge the common law. It is opposed. Opposed. Again, different box of government. A monarchy versus a republic versus a democracy. Each one has its own fundamental law. So, with that, no further ado there, folks. Have a wonderful night. Thank you all for being here and hope you enjoyed the show tonight. Blue sky out here on YouTube. Our courts have become bar courts. It's all Roman civil law. Code. Back under the monarchy. Under that Code of Civil Procedure Act. None of our courts are common law courts that are not courts of the United States, Inc. Under the Roman civil law, the Code of Civil Procedure Act of 1873 federal, and you'll have to find it in your own state legislative acts, enactments. In Idaho, it was 1881 in the 11th legislative session for the territory of Idaho. God bless y'all. Have a wonderful night. We'll see you next Monday night. Things are going to get interesting, I can tell you that right now. It's coming. With what Tanawa's bringing there, this is all going to go to the Supreme Court of the United States of America. Per the Constitution. God bless. And Wednesday night workshop. We'll see you over there if you, those of you want to be in, get in the Wednesday night workshop. Patreon. It's on my website, kirkslawcorner.com. If you're looking for help, that's one-on-one. That's tier 4. If you want to get in the Wednesday night workshop, the private classes, that's tier 3. Otherwise, you can subscribe tier 1, tier 2, or whatever you want to donate per month, or make a one-time donation and then cancel it, whatever. Do it through there or send it to the office, 6477 West Fairview Avenue, Boise, Idaho. That's Suite G, as in golf. Boise, Idaho 83704. It's on my website. Address is there if you'd like to help support me in my endeavors here. Through the snail mail, those postal money orders, cashier's checks, any of that, regular money orders, cash wrapped aluminum foil, personal checks, whatever. All that fiat currency stuff. But, yeah, I greatly appreciate the support that I have, the people have given, and God bless you all. Have a wonderful night. We'll see you.